Okay, well, good morning. I'm honored to speak with the committee on this important matter related to Bill S-245. As has been mentioned, my name is Dwight Newman, and I'm a law professor at the University of Saskatchewan. I'm sorry I couldn't
Excuse me, we're having
join
trouble
you.
hearing. Okay, shall we proceed?
It's okay? Sure. So I'm sorry I couldn't join you today in Ottawa. I'm in Toronto speaking at the Canadian Energy Law Forum in a few hours. So I carry out a broad program of research with a significant part of it focused on the nexus between constitutional law and resource development, and constitutional law there including very significantly Indigenous rights. We're going to have a fair amount of time to address the matters that may be of interest to you if you wish to ask a lot of questions. In my opening minutes, I'm going to highlight just several points that I set out in my written brief, and I want to focus particularly on three key points. First, I want to say that the use of the federal declaratory power in section 9210C is indeed constitutionally available for the Trans Mountain project if Parliament wishes to use it. And on many past occasions, it has been used in instances involving interprovincial or international projects, as well as projects within a province. And so I list some examples in the footnotes within my written brief just to establish that point. I would also add that many of these uses were in the context of what is sometimes called private legislation, focused on rights of particular parties or on particular projects. And that kind of legislation has often originated in the Senate, as I also set out in the brief. So it's not unusual that this sort of a bill using the declaratory power would originate in the Senate. The declaratory power hasn't been used that much recently, but it has been actively used in the context of nuclear regulation, even in current times. Second, I want to say that the use of the declaratory power in this bill would offer symbolic clarity that Parliament is taking full legislative jurisdiction over the Trans Mountain project. Those sorts of legislative steps should not be necessary, but in the present circumstances, they seem to be. The constitutional effect of a declaration under Section 92 sub 10 sub C can vary based on features of the legislation in which it's used, and that legal principle is found in a complex 1993 Supreme Court of Canada decision in the Ontario Hydro and Ontario Labour Relations Board case concerning the use of the declaratory power in the nuclear context. The intent of S-245, as I read it, is to clarify exclusive federal jurisdiction on the Trans Mountain pipeline, and it would contribute to doing that. Third, in several pieces I've written recently on the Trans Mountain project, I've actually suggested that Parliament could provide more legal certainty with legislative steps that go beyond symbolism. By establishing a set of regulatory powers over the pipeline that clearly created what's known as a complete code in the constitutional context, Parliament would benefit from the constitutional doctrine of federal paramountcy, under which any provincial regulation in the same area would be overridden because of a conflict between the federal legislation and the provincial regulation. In my written brief, I derive some sample regulatory provisions from past uses of the declaratory power and suggest that those could be the type of thing that could be included in S-245. There would be better drafting than what I've offered there. They are based very much on old drafting style. But of course, all of the resources of the Justice Department could be brought to bear if there were a full follow-through on the commitment of the government to legislative steps to provide certainty for the pipeline. If things have to progress from the Senate, the Senate will have to do what it can do with S-245. In any event, Canada does have the legislative powers to get this project done if there's the will to do so. And with that, I would conclude these remarks and simply open myself up to questions on the constitutional dimensions related to the declaratory power and S-245.
Thank you very much, Mr. Newman. And I've got a short list here. Senator Sinclair.
Hello, Mr. Newman. My question to you has to do with your other area of expertise, or perhaps a related area of expertise, and that has to do with the issue of Aboriginal rights in the petroleum industry or the resource industry generally, and the impact that could be had with regard to the exercise of the right to consultation, the right to involvement. Have you had a chance to look at the court cases that have been filed in the various courts by the First Nations with regard to the failure of the National Energy Board to consult with them properly or to consider their position properly in the process of approval?
Yes, indeed. And I referenced those in the written brief and in my writing on the Trans Mountain project of late. I've tried to emphasize that this is a part that has been forgotten in a lot of the discussion. There's a very important discussion to have around the federal-provincial jurisdictional issue, but there's a very important part connected with those cases. And of course, those were heard back at the Federal Court of Appeal in October and at the British Columbia Supreme Court in November. And there would have to be a hope that those decisions come through. The court is best placed to assess all of the complex evidence that was presented there. And hopefully those courts will render those judgments. And I would see it as vital that the government respect the Indigenous rights dimensions, of course, and it needs to be responsive to anything that comes from those judgments.
Whatever the courts say with regard to Section 35 and the clarity around what those rights might mean, would you agree with the suggestion that any declaration that this is a work to the advantage of Canada and therefore a federal undertaking that is subject to federal jurisdiction is still subject to the Section 35 rights of Indigenous people under the Constitution?
Yes, I mean, it's a statement about federal versus provincial jurisdiction. The Section 35 is a constraint in legal terms on both levels of government, but part of the cooperation within a diverse Canada.
All right, thank you very much.
Senator Galvez.
Thank you very much. I think we are all aware that as parliamentarians we have this power to declare a project of national interest, but I think the question is when to use when we use this card. And in this case, we have some questions. Like I mentioned to the previous witness that to ensure success in negotiation, it should be individual, private, incitative type of negotiations instead of being coercive and do it in the public place or being like enforcing this type of bill. So in analyzing the global picture, I wonder, it seems ironic to declare a project of national interest and using a tool that will confront provinces, and therefore it's going against the unity of the country. And the other point I want you to comment is, have somebody evaluate the commercial cost of putting frictions between provinces, and what does that make to the whole Canada in losing monies because we are putting provinces in opposition?
Well, on the second point, I think I'd have to defer to the expertise of economists in terms of the assessment of any costs that exist out of different types of policies. Speaking to the first point, I would say simply I don't see it as running counter to national unity for the federal government to use its powers that are explicitly provided for it under the Constitution. And this bill shouldn't be necessary. Section 92 sub 10 sub A already provides the federal government with jurisdiction over interprovincial transportation and communications, and obviously the area in which this committee routinely works. And there are a lot of constitutional doctrines that back up the exercise of powers under that power. However, in the present circumstances, there seems to be a lot of questioning of that area of federal jurisdiction, phrased very indirectly at times. And there have been statements put around whether Parliament could use the declaratory power or not. I've tried to respond to some of those here. And if you agree that it's very clear that Parliament can be, of course, I'm not questioning that. But there are people who've floated comments in the press suggesting that it couldn't use it legally. And so one of the things I'm saying is legally it can. And second, it is within the explicit powers of the federal government. So I don't think that that's an interference with national unity. I think it's actually a carrying out of the constitutional purposes that the federal government can construct interprovincial transportation infrastructure.
I think that you are aware, and because it's been in over the media, that the provinces are already threatening each other with commercial bans and commercial limitations. So I think that it's pretty evident that they are already in a confrontational situation. So this bill, or the one that is being put in the other chamber, which I think has the same type of purpose, at the end, will it accomplish? Will it accelerate, or will, I don't know, will it give the results that some portion of the population thinks to want, which is the construction of this pipeline?
I think this bill provides an environment of legal certainty for the project. Now, there are a lot of other factors that come into play in terms of what happens from here. Certainly, if a province decides to continue to disregard the rule of law at that point, there would be complexities that arise. If there are protesters who disregard the rule of law in some manner, all kinds of things could happen. It's not my place to speculate upon that, but I'm speaking simply to the reality that this bill would provide a legal certainty for the project, and things would have to develop from there in terms of the more political dimensions.
Thank you. If there are no other questions on first round, I'm going to move to second round, and Senator Sinclair.
That quick? You've either provided all the answers, Professor, or else no one can understand what you've said. So let me see if I can help here. We've already discussed the impact and the relationship between Section 35 and the declaratory power generally. But the court cases that are before the court clearly raise the question of whether or not the duty to consult has actually been met, and particularly those cases that have been filed by the First Nations. Would you agree with that?
That's one of the principal issues raised in those cases, and that's before the courts.
Now, in the case law to this point in time, with regard to the issue, the courts seem to have said, the Supreme Court in a couple of decisions appear to have said, and maybe you can comment upon this, that projects should not be allowed to proceed until the duty to consult has been met. And if the court decision, so my question really goes to this, if that's the case, the court decisions clearly raise that question, and that's an open question for the courts to decide. How are we then going to reconcile the fact that the pipeline proponents seem to have, Kinder Morgan in particular, seem to have put so much money into the ground to get this pipeline to the point where they're now saying they're not going to spend any more money if consultation may not have been in fact completed?
Well, that's an immensely complicating feature to our present regulatory environment, that companies are being expected to spend $500 million or $1 billion and not have knowledge of whether there might be some other issue that comes up by surprise. And we saw that certainly with the Northern Gateway decision, where the Federal Court of Appeal, after the project proponent had spent $500 million, ruled that there was still further consultation that needed to be done. And with a change of government, the new government decided not to go ahead with that further consultation that would have been required. In this instance, the court is best placed to assess all of the evidence that's been put forth before it, or the two courts, I should say, and they'll have to make that assessment. If they determine that there were inadequacies in consultation, presumably the remedy would be that more consultation would be carried out. The government would need to carry that out in good faith if it wishes to potentially proceed with the project. And would need to consider that further consultation and what came from it, and if necessary, accommodations that arose. But right now we're speculating about a court decision that might or might not come. I mean, the government's view, certainly, that it's articulated is that it has carried out very extensive engagement and consultation. The government has tried to learn lessons from the Northern Gateway decision and the judgment in that case, and to improve the consultation process that was carried out on this project in response to that. And it's possible that the government might well win those cases. I mean, that remains to be seen, depending upon the court's assessment of the evidence in those cases.
Yes, they haven't won them yet, but in this Carrier-Sakani case, which you referenced, in the Clyde River case, which you also referenced in your material, the court seemed to say that until consultation has been completed and the consent or the consent of the First Nations involved has been received, so either in either case, if consultation is not yet completed, the project cannot be deemed to be in the public interest. Do you agree with that statement?
There certainly have been court statements that a project shouldn't proceed until consultation has been completed, although there may be continuing consultation during construction, and I think that's a very positive thing where that bears on elements of the project proceeding. But a sufficient consultation related to the approval of the project needs to have occurred before a project is approved and proceeds. But that said, that assessment is initially in the hands of government, subject to a court challenge to that. And if the government's view is that it has carried out that consultation, it could authorize a project to proceed without having a court hearing in every case. The duty to consult today is triggered in Canada several 100,000 times a year. Most of those instances see projects proceed without controversy, with good consultation. There are certainly times where consultation efforts should be critiqued. But in many cases, we see good consultation efforts proceed. We see many instances of agreement with Indigenous communities. But we can't have a court proceeding in every instance, and governments are entitled to proceed, subject, of course, to a court challenge. And in this case, there are court challenges. It's very important that those be heard and decided.
I may be the only member.
A couple speakers after you, Senator Singh.
I was going to say I may be the only member of this committee that's interested in continuing this conversation ad nauseum. So let me see if I can just ask one more question, Chair. Thank you. It has to do with the degree to which there may still continue to be a provincial jurisdiction remaining even after the declaration that this bill appears to authorize. In the Ontario Hydro case, for example, I think the Supreme Court of Canada put a very significant limitation upon the federal jurisdiction to regulate and control only those workers in the industry who are actually involved on behalf of Ontario Hydro in the nuclear component of their work, and that they didn't necessarily impact upon those who were involved in the project who were not involved in the nuclear component. Do you have a comment to make with regard to the limitation on the federal undertaking jurisdiction and the ongoing possibility of provincial jurisdiction here?
So thank you for the question, and thank you for the attention to the Indigenous issues as well, because I think those are vital to continue bringing to attention here. On this question about the Ontario Hydro decision, I'll just say it is a complex judgment. there's a 3 to 3 to 1 type split, which never enhances the clarity of a Supreme Court of Canada judgment when you see that kind of a split. I would read the combination of the two judgments in the majority to imply that the consequences of a use of the declaratory power depend upon the particular intentions spelled out in the legislation in that instance. And so in the instance involved in that case, the effects were subject to some limits. In Bill S-245, one might read a broader intention, and one might read the legislation as further displacing provincial jurisdiction that might otherwise have existed through the intention to use the federal jurisdiction. That said, that would be clearer if there were additional provisions added to the legislation. And they might or might not take the form that I've included in the written brief, but something that would set out more of a federal covering of the field, as it were, in the context of the project, would further use the doctrine of federal paramountcy. And in the case of a conflict between a federal law and a provincial law, even where they're both entitled to enact the legislation, federal paramountcy says that to the extent of any conflict, the federal legislation takes priority, and the provincial legislation then doesn't operate to the extent of that inconsistency. So in some of my recent writing on Trans Mountain, that's the sort of approach that I've suggested as a legislative path forward, being very precise about the federal-provincial issue if the federal government wishes to assert its powers. That doesn't deal, of course, with the Section 35 issues, which are an additional set of legal issues.
Thank you, Madam Chair. I found that very exciting.
Good, I'm glad. Senator Dawson.
No.
Oh,
Thank you very much. Dr. Newman, thank you very much for being available, and thank you very much for the detailed work that you've done to be of assistance to us. I simply have one question. I read from what Senator Sinclair, my esteemed colleague, is suggesting, is that in his view, consultation is not complete until there is consent. Do you agree with that?
Well, I don't know if that's what he's articulated or not. That's not what I heard in his question of a moment ago. If he were to make that assertion, or someone else were to make that assertion, what I would say is consent certainly seems to be able to substitute for consultation. So if consent is achieved, that may replace the need for consultation. And that's the structure under which we're operating in the context of impact benefit agreements negotiated between industry and Indigenous communities very routinely. There's reference to that idea in the Chilcotin decision of the Supreme Court of Canada in 2014 as well, that if there is consent, that effectively resolves all the issues. But nothing in what the Supreme Court of Canada has said thus far suggests that consent is the requirement under consultation, other than possibly in some very limited circumstances. So consent is the standard requirement in the case of an established Aboriginal title area. That's not surprising. Where it's established that somebody owns land, the usual standard for someone else to use that land would be consent. But apart from that circumstance, there's been no suggestion that consent is the general standard. Consultation varies across a spectrum. It's a complicated doctrine as to what exactly is required under it, but the current state of Canadian law does not seem to reflect a requirement of consent.
Thank you very much, Dr. Newman. Thank you, Chair.
thank you. Are there any other questions or comments? I can see you burning there, Dr. Senator Sinclair.
No, I'm tempted, but I will. Well, you'll hear a lot about this as we go forward, let me assure you. Tomorrow we have a panel from First Nations leaders who are going to speak to us about this question, but generally the issue of consent is one that they're going to raise, Are you familiar with the United Nations Declaration on the Rights of Indigenous People and its endorsement by Canada?
Yes, I am.
And do you think that, from a constitutional perspective, what do you think that endorsement does to the existing state of the law in Canada, if anything?
Well, so there have been a couple of endorsements by Canada, of course. There was an endorsement in part in 2010, and then there have been subsequent endorsements in 2015, 2016, more recently. And those have been phrased to some extent in less qualified terms, or at least purported to be, although some parts of the phrasing of the 2016 endorsement did refer to still carrying this out in conformity with the Constitution of Canada. I would say in general terms, those endorsements themselves don't have any particular legal effect. They do represent a commitment by Canada, and at the policy level, going beyond the constitutional context, there are questions in terms of how the government wishes to proceed, given that it's stated itself to be seeking to conform to the UN Declaration on the Rights of Indigenous Peoples. The other thing I'd say is, of course, there's another bill in progress through Parliament concerning the UN Declaration on the Rights of Indigenous Peoples, Bill C-262. And if adopted, that bill certainly has effects in relation to the status of the UN Declaration on the Rights of Indigenous Peoples. At this point, though, I think a description of the present law would say that there's not been an incorporation of the UN Declaration on the Rights of Indigenous Peoples into Canadian constitutional law. It's been argued before the Supreme Court of Canada in many of the recent Section 35 cases, and the court has never cited to it. That's not to say they might not in future, and then I would describe the law differently. But trying to just describe the present state of the law, I would say that at this point in time, it does not appear to be part of Canadian law. Now, this is a complex space, and it's certainly a space in which, understandably, there's an enormous amount of advocacy around the UN Declaration on the Rights of Indigenous Peoples. You know better than anyone the recommendations of the Truth and Reconciliation Commission, of course, in this regard. And it may be that does lead to changes in Canadian law in the coming years, but in trying to describe the present state of the law, I would say that's not yet occurred.
I'm going to have you.
As I said, ad nauseum, Chair, I could go on, but I'm prepared to follow your lead if you wish to end this at this point. I'm fine.
We still have time, but do you want to take one more question, Senator Sinclair, or one more comment?
Well, it is to pick up on the point that you just made, Professor, and that has to do with balancing the interests that are at play here. So if the interests of the pipeline are matched up against the interests of Indigenous people as endorsed by the UN Declaration and the policy decision that Canada has made to endorse the UN Declaration, how do you see that coming out of the shaker?
Well, that's a complicated question, of course.
That's why I asked.
I would tend not to phrase it in that way. I don't think this should be portrayed in oppositional terms, in the sense of, well, here's Canada's interests and here are the interests of Indigenous peoples under the Declaration. I think there still needs to be room for a national interest or a public interest within which Indigenous rights and respect for Indigenous rights is a very important component. And I think there could be different judgments reached, frankly, by different people, depending on their view of particular aspects of the Declaration and its relation with what has occurred. Some key aspects of the Declaration, the legal interpretation of those is not yet clear, honestly. So something like free, prior, and informed consent within the Declaration, which obviously is something that's raised. There are at least 3 different trends in terms of interpretation of what the free, prior, and informed consent element of the UN Declaration on the Rights of Indigenous Peoples means in natural resource type settings. It's my understanding that the Justice Department may be providing a perspective on that in the context of the hearings around Bill C-262 in the coming week or weeks. And that will be of interest in terms of what the Justice Department says in the Canadian context on how the Justice Department is interpreting free, prior and informed consent within the Declaration. But there are a lot of complexities there, and so I wouldn't try to make an assessment offhand in terms of that question of considering the Declaration. How does one read the national interest? But I think that is a question that Parliament needs to squarely face as part of this. That there is a policy commitment there that needs to factor significantly into the overall read of the national interest.
Thank you, sir. Thank you, Chair.
Thank you. If there are no other comments, I'm going to thank you very much, Mr. Newman, for being with us today.